In this Model Number 4 video lecture, you will receive a quick summary of the important issues found in this module. This video lecture is meant to be a broad overview of the topics covered in the readings, but not be a replacement for your text readings. It is important that you read your text each week so you don't miss any details. These lectures will highlight the important broad issues in a top 10 type style countdown. Let's get started. Number 10. People over a certain age in most states around 14 years of age are inferred to be capable of formulating the necessary mental frame of mind to commit a crime. A rebuttable presumption exists under most state statutes and common law that children between the minimum age, usually around 7, and the maximum age, usually around 14, are presumed to be without criminal capacity to commit a crime. The U.S. courts look to a variety of factors when the capacity presumption is at issue, and they usually hold that the younger the child, the stronger must be the evidence of mental capacity. Thus, it is harder to prove a child committed a criminal act. Number 9. Many states have separate laws that classify minors as juveniles and thus sent to a different criminal justice court system. These are juvenile courts. The concept of juvenile justice is based on the phrase parens patriae, which is Latin for parent of his or her country. The power of the state to act as a guardian for those who are unable to care for themselves, such as children or disabled individuals. For example, under this doctrine, a judge may change custody, child support, or other rulings affecting child's well-being, regardless of what the parents may have agreed to. There are laws in which a juvenile can be treated as an adult and charged as an adult if their mental capacity has fully formed. Number 8. The insanity defense is afforded to those defendants who do not have a mental capacity to distinguish between right or wrong at the time of the crime. Some states place the burden on the defendant to prove the defense by preponderance of the evidence. Other states place the burden on the prosecution, i.e. the state, to prove, beyond a reasonable doubt, that the defendant knew from right from wrong at the time of the crime. Insanity defense is a very controversial defense. If a defendant prevails in their insanity defense, most criminal laws confine the individual to a mental institution for life. Number 7. Only about 2% of the defendants charged with serious crimes use the insanity plea. In most jurisdictions, the burden is on the defendant to prove the insanity defense, only by a preponderance of the evidence. If a defendant is found insane at the time the crime occurred, a judgment of not guilty by reason of insanity is then entered by the court, and the defendant may never again be tried for that offense. The McNaughton case and the right and wrong test are insanity tests that claims that defendants are not legally responsible for their acts if, due to deficit of the mind, I should say defect of the mind, at the time of the crime, they were unable to understand the difference between right and wrong. A defendant may be found guilty by mentally ill if all the following are found beyond a reasonable doubt. Number 1, the defendant is guilty of the offense. Number 2, the defendant was mentally ill at the time of the offense was committed. Number 3, the defendant was not legally insane at the time the offense was committed. Number 6. Mental conditions that do not satisfy the insanity defense range. For example, many mental conditions do not rise to the level of insanity and thus do not provide defense to a criminal conduct. Battered woman syndrome, television intoxication, premenstrual syndrome, or so-called cultural defenses are rarely successful. The voluntary use of drugs or alcohol does not qualify as a mental disease, nor does compulsive gambling. Number 5. A defense for criminal responsibility based on the fact that because of the mental or emotional conditions, the defendant did not possess the required mens rea for conviction of a crime charged is called diminished capacity. Number 4. The defense of insanity, diminished capacity, and age are considered legitimate excuses for criminal behavior that reduce or entirely eliminate the defendant's blameworthiness. A criminal law is designed to punish only those who are truly blameworthy for their conduct. Insane defendants or those too young to understand or appreciate their actions cannot be considered worthy of society's blame. So, while it's clear the defendant engaged in the actus reus of the crime, their behavior is excused because they could not form the requisite mens rea to be held accountable for their actions. Diminished capacity defenses are controversial because they do not eliminate blameworthiness entirely. Number 3. Business entities commit crimes and can be charged with offenses, charging both the entity and the individuals who actually run the business entity, and there is an establishment of their actus reus and mens rea. Business crimes are often classified as white-collar crimes and include mortgage fraud, false advertising, environmental contamination, and alike. Number 2. The rules for making corporations liable for actions taken by the officers, directors, or employees. Corporations can be vicariously, criminally liable for actions of their agents if the offense is minor, a duty is specifically assigned to a corporation, a statute explicitly creates vicarious criminal liability, or the person committing the crime is acting in the interest of the corporation and is a high managerial agent. Number 1. Business entities are principals and they hire employees who are their agents. Traditional principal-agent theories have been used to attach criminal liability to the business entity for the acts of their agents. This is a form of vicarious liability. Thus, if an employee commits a crime to further the business interests, the business entity can be charged also with that crime. Usually, most criminal offenses involved violations of environmental laws by businesses.